So we have reached the end. This is a really important panel, and this is the part where I start to get sentimental about Mike, and I will probably do so during the reception. But this has been been a really special day. It's been some great panels. This was particularly special to Mike. Mike always moderated this panel, and so we had to search high and low, and we're lucky to have Joe Huddleston step in and moderate this panel. I think this is pretty unique to what we do here. And this is coming from somebody who's not an attorney, who doesn't appear before tax court judges. But I think it shows the diversity of what we're trying to cover here. And there's a lot of accountants in the room. I think you're still going to find a lot of very interesting, insightful comments from this panel. So having access to these tax court judges is immensely important. And I'm sorry that Mike's not here to handle it, but there's nobody better that could cover this than his former colleague, Joe Huddleston. So I'll turn it over to you.
Wow. I know that we've had an unbelievable day. And those of you who've been here know that there's been an incredible amount of very useful information provided today. And hopefully we're going to cap that off with a little bit of information based on where the rubber meets the road. Those of you who go through this process, whether it's in administrative or legal or technical aspects of this, know that ultimately a lot of the questions that we talk about end up in front of these folks at the tax court level, where a lot of the issues get resolved, or at least the process is taken to the next level. And there's a lot of things that you've heard today about a lot of different areas. We're going to talk about some of those. We're going to talk about apportionment, but probably more importantly, at least in my mind, we're going to talk about some cases that are important to these judges. We're going to talk about process that they see. We're going to give you the opportunity to ask them directly questions. I'll give you a little caveat here. Please don't ask them questions about direct litigation that's currently going on, because in all likelihood, they're not going to be able to answer them anyway, and I'm probably going to throw myself in front of you and say, no, you can't ask that question. That's a very narrow range of areas that are precluded, so it's wide open. We're going to talk about things we talked about from the very beginning. We're going to talk about Mormon a little bit. Everybody else has talked about Mormon, so why shouldn't we talk about Mormon? We're going to talk about, I didn't think I was going to talk about complete auto, but Steve raised complete auto, and I may have to, before it's all said and done, I may have to say a few negative comments about complete auto. We're going to talk about due process. You're going to see due process as a trend throughout all the things that we talk about. What comes before these courts, how they deal with the problems of due process, how they deal with the problems of fundamental fairness, and whether or not fundamental fairness is even a consideration in the 21st century, given the cases that we've seen historically. So we have a broad range of things we want to talk about. We're also going to talk about some non-tax cases that have some implication in the tax world. We're going to talk just a little bit about a New Jersey case, the Murphy versus NCAA, where the courts have raised the ugly head of anti-commandeering in the 10th Amendment. Does anti-commandeering have anything to do with state tax issues? Some would say no. I'm one who says it's a very dangerous proposition and needs to be resolved. The other things that we're going to talk about, of course, is we're going to talk a little bit about deference. So we're going to talk about Lober-Bright Enterprises and the Chevron doctrine and how that may or may not impact cases at the state level. There's a lot of areas for us to cover, and in the 3 hours I've been given to cover it, you will be relieved to know it's been made very clear to me that this panel is the only thing that stands between you and a wine reception. So we're going to move through these processes as quickly as we possibly can. Once again, let me encourage you to ask questions if you have them. And we're going to begin. Anthony, at the far end, I'm going to ask each of these judges to identify themselves and perhaps tell us a little bit about how they got into the position they're in. So, Anthony, if you'd start for us.
Thank you, Joe. My name is Anthony Wisniewski. I'm the Chief Judge of the Maryland Tax Court. I've been on the bench since, on or about September 30th, 2020, so pandemic and all that. No plexiglass in our courtroom, by the way. The Maryland Tax Court is an administrative agency, part of the executive branch. There are 5 judges on the bench. All of our judges happen to be attorneys, and we were appointed based upon matters of geography, etc. We were appointed by the governor, as was I. We have been around in our current iteration since about 1959. However, our pedigree goes back to 1878, when it was known as the Maryland Tax Commission. The Maryland Tax Court has jurisdiction over all matters of taxation over the entire state of Maryland. You have controversies that arise under the Comptroller of Maryland. You have a representative here today from the Comptroller, which would largely be income tax and sales and use tax for conversation purposes, the 2 big ones. A significant majority of our docket concerns assessment appeals, commercial and residential real estate assessment appeals, and that agency that oversees that aspect is the State Department of Assessments and Taxation. We also, however, hear a sundry number of other one-off tax cases that arise out of various municipalities with municipal taxes. So it's a rather interesting arrangement, and it always provides for ample variety. Thank you.
Let me ask you before we leave, Anthony, what happens with decisions of your court? If they are appealable, who would they be appealed to? What's that process?
Yes. So to start with, and I'll stick with the state level for just conversational purposes. When a case comes up through the Comptroller or the State Department of Assessments and Taxation, their hearing officer at the Comptroller level or their chief assessor at the SDAT level will eventually trickle up to the tax court if it's appealed. On the assessment side, I know we're not really here on property tax, but it's a big, big issue. We have another administrative body called the PTAB, the Property Tax Assessment and Appeals Board. That body, its decision can be appealed de novo to the Maryland Tax Court. If either controversy that arises from a comptroller hearing officer or an SDAT PTAB body wishes to be further appealed, it will go to what's called the Maryland Circuit Court. Maryland has an upper and lower trial court. The Circuit Court is the upper court, the ones with the juries. They will hear the case. And then as a practical matter, more times than not, it will be swiftly appealed again to what we now call our Maryland Appellate Court, where you have a number of esteemed jurists with a substantial tax background. Ultimately, maybe it could go to the Maryland Supreme Court, although that is the exception, obviously, and not the rule.
Thank you. Justin?
Good afternoon. My name is Justin McAdam. I am the judge of the Indiana Tax Court. I came to this position...
Before you go on for that, I take note of the fact that you said the judge.
Yeah, I am the most senior and most junior judge on the Indiana Tax Court. Also the chief judge and every other judge of the court. The Indiana Tax Court's a bit of a unique animal. It is an appellate court, one of 3 appellate courts in the state of Indiana. You have the Supreme Court, the Court of Appeals, and the Tax Court. It created in 1986. The tax court has jurisdiction over all tax matters in the state of Indiana. So that's both property tax and state taxes, income, sales, etc. So all of those cases arise through administrative agencies. They're, in the case of property tax, you have an intermediate administrative agency that really serves as the trial court or performs the trial court function for purposes of property tax appeals that are litigated up from the counties. And then the rest of the cases on the state tax side come up through the Department of Revenue out of that administrative body. Those cases come in different postures. The Department of Revenue cases come to my court de novo, which means that we hold a trial, and then we'll issue a written decision. The property tax cases, however, come to me in an abuse of discretion posture, and so they come with a record that I'm reviewing, and it's a much more traditional appellate posture. In terms of the court, what do I want to say about the court there? I think I'll stop there for the moment on the court itself. Little bit of background about me. I came to the court sort of by a circuitous route. I didn't expect to be the tax judge when I graduated law school several years ago. But I spent the last before I was appointed in 2023. I spent the 8 years prior to that working for the executive branch of Indiana state government in the Office of Management and Budget. And among other things in that role, I was responsible for overseeing tax and fiscal policy writ large for the state and for the governor's office across the state of Indiana. And that meant being involved in a lot of different issues, both legislative issues involved in administrative tax policy, conversations about administration of agencies, but also taxpayer issues if they were particularly thorny or of particular significance, and so had a lot of engagement there, among other things. The OMB gets engaged in a number of things. For a while, I was the president of a couple school boards, essentially for the state of Indiana, because we took over a couple school corporations, and I was responsible for overseeing that. So that was a totally different kind of experience than what I've been doing here. Prior to joining the OMB, I was a campaign finance lawyer, so not unfamiliar with highly regulated areas, but obviously in a much different context, and really spent my time there both between litigation and transactional advisory work, and so I did a number of different, had a number of different exposure, primarily to state campaign finance law, often working with clients or challenging, who were trying to move money between states or otherwise trying to challenge state laws. Prior to that, I was a clerk for the Indiana Supreme Court, for the Chief Justice at that time, and then attended a school that's known for its basketball program. No disrespect to the current institution, but Indiana University may or may not have won a few national championships in its history. And we don't have to compare when they were won. That's not relevant. What's really relevant is that we've won more, and so we'll just remember that. I also attended Purdue University, so I'm capable of bridging gaps in my state, bringing that together, and then attended Harvard for law school in Boston. So I think that's enough about me, and I'll pass the mic.
Justin, thank you. I will forewarn you that given those comments, I'm going to come back to you in just a second with a follow-up question. So, Marla.
Hi, everyone. I guess I am the oldest. The tax court is also the oldest compared to these gentlemen here. The tax court started in 1978. I started as a tax court judge in 2009. Before that, I was in the Attorney General's office representing Division of Taxation before the tax court, before the bankruptcy court, before the Third Circuit, before the New Jersey Supreme Court, and tried to go to the U.S. Supreme Court, but they wouldn't accept my certiorari petition. I became presiding judge in 2011, so I supervise the tax court, the management, and the other judges. We have about 11 of them right now, so and we do just tax, just like the Maryland tax court and Indiana. We are called a trial court, but all of the decisions, they come, like in your case, from administrative agency decisions. So you, for example, you have a business, you don't pay your tax, you took a deduction, did a single source and said, I don't want the single source, I want the multi-factor. Then you would go to the Division of Taxation, they agree, don't agree, then you come to the tax court. So it's sort of like an appellate, but it's all de novo. My decisions go up to what is called the appellate division, and from there it goes to the New Jersey Supreme Court.
Great, thank you. We've heard a lot of discussion throughout the day about uniformity, disuniformity, and its impact on taxpayers. And along the line of uniformity, I will tell you a story that years ago in a prior life, I was Commissioner of Revenue in the state of Tennessee for a number of years. And all of those folks who talked about uniformity, when they challenged a tax assessment and ultimately got into my office, I never once had any business activity come into my office and say, treat me just like everybody else. Not one time. So along those lines, I will tell you that there's a general impression that at the state court level, a lot of home cooking goes on. You know, I'm sure you're aware of that. So Justin, I would ask you to begin with, did you ever rule in favor of the taxpayer?
I rule in favor of the taxpayer? I have. I haven't kept count of my formal split between taxpayer and department or government. I actually haven't been able to rule in a Department of Revenue case yet because they used to report to me, so I've had to recuse from every case that was pending when I took office. So I'm just now beginning to pick up cases from the Department of Revenue. But actually, in my life, I sort of viewed my role when I was at the Office of Management and Budget. I viewed my role not as an agent of the department. So the department was, OMB was an umbrella agency of the Department of Revenue and other agencies, tax and fiscal policy agencies within the state. I always viewed my role and my charge as one of getting to the right answer. And so there were a number of times, and if you know anybody at the Department of Revenue in Indiana, they'll attest to this, where I overruled the department internally and said, no, we're not going to do that legislative, we're not going to pursue that legislative policy. No, we're not going to treat that taxpayer in that way. No, we're not going to adopt that policy that way. There were a number of times I sided with them as well. I mean, they're very smart and very capable individuals. But I always viewed my obligation as one, and it's something that I've enjoyed particularly about the roles that I've had in public service, is the opportunity to really seek out the right thing, the right answer, and try to get there the best I can with the resources and the information I have at my disposal.
Anthony, did I understand correctly that you're basically an executive branch agency? Did I misunderstand that?
We are indeed. We fall under the executive branch. As the chief judge, I'm the agency head. So I'm also hiring staff, evaluating staff, managing dockets, budgets, legislative audits. We got a completely clean audit, no findings, by the way, and doing the various other aspects of hearing cases. One thing I also do, however, is I review every single order that goes out of the tax court. So I personally review everything, and I apply my signature to nearly everything to ensure that when it's going out, it has ample set of eyes on it, and it's being done correctly.
But I guess given that structural thing, I would come back to you and kind of ask you the same question that I asked Justin. That do you share his feeling that it's not your role to protect the agency, or is that part of your role?
Well, I think Justin is a very likable fellow. That being said, I will interpret or reinterpret your question to be asking you on matters of deference. Shall we go there?
Well, I'm going to get to deference, but if you want to address it right now, go right ahead. Go right ahead.
So in Maryland, there is agency deference, as I presume there would be in every jurisdiction, but it's in Maryland as well. And in Maryland, agency deference is given to the agency that enacts and enforces and manages the statute. So if we have a comptroller-related issue on income tax or sales and use, the tax court will show deference to the agency known as the comptroller and adhere to a presumptiveness of correctness on what it is that they are bringing forward in the controversy on appeal that goes to the tax court. The same applies for the State Department of Assessments and Taxation. Now, once the petitioner has met his or her burden, then the playing field gets leveled rather quickly, and the tax court renders a decision. Now, you might be asking, well, the Maryland tax court, if you're also a state agency, who gets the deference? Well, there was a recent Maryland Supreme Court case on this very issue called FC Gen, which I believe was decided at the very tail end of 2023, or maybe it was 2022. The years sort of congealed after a while. But our Maryland Supreme Court made very clear that the agency that is charged with the statute is to be shown deference, which, as a matter of court practice, has always been how Maryland tax court judges have viewed and treated those agencies. Obviously, because the Maryland tax court is within the line of appealability and has adjudicatory responsibilities, the appellate courts are certainly listening to and reacting to and opining on Maryland tax court decisions, which are upheld more routinely than they are struck down. So I'd say that there's some latent respect there of the tax court as well.
Marla, can you talk to us a little bit about New Jersey and their relationships, as we'll kind of follow along this deference concept with after the Lover-Bright decision at the U.S. Supreme Court level, basically obviating the Chevron doctrine. What was New Jersey's position on this, both prior to and currently?
Hasn't changed, which is deference is given. The only, sorry, I forgot. My voice is so loud, I don't need this. It hasn't changed. Pre-Loper, post-Loper, it was always give agency deference to an agency decision-making, because they are the executive branch that are delegated from the legislature the authority to enforce, to interpret. And of course, there's always a caveat that as long as it's reasonable. If it's unreasonable, if it's arbitrary, then they don't get any deference, as long as it's reasonable. And after the lower decision...
That's a pretty thin requirement, isn't it? And it falls back on you to make some determination as to reasonableness.
Yes, but like the prior panel was talking about the presumption of correctness in terms of the apportionment, who decides the alternative, who gets the burden. They all come to us with a presumption of correctness. The basis, I think the logic is that the government can do no wrong. The government is the government. It's protecting the people. So, I mean, that's why you get the deference. But it's not an absolute deference, never. The presumption of correctness also in New Jersey is, although I disagree with the senator who said that it's a very low bar to match New Jersey, the presumption of correctness bar is low. That, I agree, is low. As long as you have, and the panel was saying, you have something decent, you have something quality, you have some good proof, and I have decided that, you overcome the presumption. And then you just persuade me how I'm better and I do a better job. And what the panel was saying, you got your proofs, you got all your ducks in the row, you show me everything. Demonstrative evidence is phenomenal. I had a case and it's not apportionment, it's sales tax, and it was the running of a bakery. And Division of Taxation said they take these dollies and they put the to-be-made loaves of bread from one end to the other end. But it's a dolly. So it's not part of the manufacturing process. And the bakery gave me a video to show exactly what they do. And it's just impossible to say that it's not part of the manufacturing process. So yes, you give me your evidence, you give me everything, I look at it and say, yep, you persuaded me. Or if you didn't persuade me, the burden doesn't kind of like shift to Division of Taxation and say, well, you prove your case now. The burden always stays with the taxpayer. But like the panel was saying, I think every panel reiterated, get your documents, do your research, know your business, which I think is very, very important, because the judges, I don't know your business. I'm listening to a version from somebody who owns the business, which to me would be a little bit more credible than somebody who's auditing the business, who's coming from a third-party angle. And the third party knows mostly generalities. We have a lot of this in mom and pop pizza stores. Well, you're selling a slice of pizza and you want to do a quick business. So therefore, you must be making ginormous amounts of sales. But that's very general. But the mom and pop business store is gonna tell me, no, Judge, this is what exactly happens. I run the business, I know. Am I more persuaded by that? Absolutely. Provided you have not just telling me in self-serving statements. It is because it is. And those are why we also sometimes reject experts, transfer pricing cases. You gotta listen to me. Why? I've been doing this for 20 years. So, back and forth that way. So, and in terms of, I think what you asked, Justin, yes, I did represent Division of Taxation as an attorney, and I think one of the panels was saying you got to prepare your client to say, it's not going to go the way you might think it go. Just be ready. And I know I prepared them for one of the cases. I said, you're going to lose. They lost. But, I did my job as an attorney to tell them that we have risks of litigation. But when you're a judge, as Justin says, you're just saying, let me listen to both sides. I'm not going to take the side of the Division of Taxation because I represented them one time. I'm not going to take the side of an attorney who I was really friendly with when we were adversaries. No.
Go ahead.
I tried not to filibuster too much about little old me, but one of the paths I had to the bench was I have spent and am still actively practicing, by the way, in federal administrative law litigation. I have represented my client in about 425 of these cases. The Loper decision, Chevron, which of course affects the federal ALJ judiciary, has been a clear shot across the bow. And all I would say is that if any of you are thinking about submitting your name to USA Jobs as a federal ALJ, think twice, because I think that they're on the back slope right now in terms of what they have been for several years now. One other thing I'd just like to mention is that I've had the pleasure, in terms of how I got to where I was, not beforehand, but directly after I actually enrolled here at Villanova Law School in the SALT certificate program. And it was just about one of the most fulfilling exercises that a man who was at least twice the age of most other students could possibly do. Aside from my certificate and my grade point average, the other thing Villanova gifted me were these pair of spectacles, which I did not need prior to a full-blown year of law school. But that also coupled with graduating from the National Judicial College with the certification in administrative law, adjudication skills, has all been helpful, albeit not prior to the bench, post-bench, but I just wanted to add a bit more about my own background and about why you shouldn't think about applying to be a federal ALJ.
I'm going to ask each of the judges to talk a little bit about an individual case that they've had and talk to us about the facts of the case, the holding and their logic behind those cases. And I'd like to do that kind of in the framework of the fact that the case that's probably been most mentioned today is Mormon Manufacturing v. Bear. And as we go down that road, I want to encourage all of you to read this case. In fact, read any of these cases and see if they actually comport with what you think they say. Because I'm here to tell you that Mormon is a failure of proof case. It really doesn't say much. It says that single sales factor is not unconstitutional. Well, that doesn't get any of us very far, because the question should have been in Mormon discrimination. It was not addressed by the court. So it's a wide open question out there when discrimination occurs in factor apportionment. The other factor that I would say to you, again, read the law. Read 86-272. Yeah. Read 86-272. It's pretty straightforward. It's pretty simple. And I will maintain that there are very few businesses out there that don't operate outside the boundaries of 86-272. Because what you're talking about here, both in Mormon in 1978, as Steve pointed out, a 1978 case, and 86-272, roughly 1960 case, you're talking about fundamentally different world. Just a different planet. It's not how people do business anymore. And just read these things and apply them, look at your own circumstances before you run off and say you actually know what these cases say. I would apply that same thing to complete auto, but that's a whole other story. So the big question that looms over all this in my mind, it certainly was the case in Mormon, is the quest for fundamental fairness. Is there a due process requirement out there for fundamental fairness in the 21st century? So given that as a backdrop, I'm not asking you to address that necessarily in your cases, but I may ask questions related to fundamental fairness as we go along. So Justin, I'm going to come back to you and let you start with your case.
Well, I'm going to do like any good judge, and I'm going to give you an answer different than you asked for. I'm going to give you two cases. So, as I said, I haven't been able to touch any income tax cases yet. Stay tuned on that front. So most of my work all of my work has been in the property tax space. But I try to think...
Before you... Let me interrupt you then and give a caveat that somewhere in excess of 40% of all taxes paid by businesses, over 40%, are property taxes. So it's incredibly important to the business community to understand the processes and the issues involved in property tax.
Well, and I will say, most of aside from the pro se property tax cases I get, 90% of them, 95% of them are business cases. They're commercial retail, they're commercial office space, they're industrial. Anyway, so I tried to think about, what would be interesting to draw out of those cases? What lesson might there be for this group that would have some broader applicability? And so the two cases I want to talk about, I really want to draw this distinction around the principle of separation of powers. And I think it goes to the question of fairness that Joe has raised. And it goes also to the question of what is the role of the court? And what's the role of the court in this discussion, in this conversation about whether single sales factor apportionment is the right system, whether it's fair, whether there's a better apportionment system, right? Who decides that? What's the court's role in deciding that? And so the first case that I'll talk about was the very first case that I had. And the case here was about a homestead exemption. This actually was an individual. He was appearing quasi pro se on behalf of his wife, but he was a lawyer, so not really pro se. And the issue here was that the husband and wife had conducted a transaction. They sold a house. They transferred a house between the two of them. He sold a house that apparently he had owned to her. I don't know a lot of the backstory. That wasn't really in the case. But he did this on December 31st, I believe. And what he was looking for is he then filed for a homestead deduction. And so in Indiana, I don't know if other states call it a homestead deduction. So it's a deduction on the value of your assessed value for your property taxes. And so he filed this, I don't know, maybe it was January 5th that he filed for the homestead deduction. And the assessor rejected it. And the assessor rejected it by looking at the statute and saying that it was filed out of time. And what the statute said was that you could file for a homestead deduction up to the 5th of the year after the tax year, the close of the tax year that you wanted the deduction for. But what the statute also said, and what he disputed, was that you had to record the contract, the sales contract, prior to the close of the calendar year for which you wanted the deduction, the homestead deduction. And so, being as he conducted the transaction on December 31st, I think it was even at like 5 o'clock at night, I think he may have said, the county offices were not available for him to record his sale contract for this home. And so the question for me was, well, what does the statute say? And we got into some really thorny questions about what are past participles and What is the meaning of is, so to speak? It was a lot of those kinds of questions. It was rather interesting, and I became an English professor for a little bit. But ultimately, it concluded that the statute said that you had to record it in the calendar year. That's what the legislature had written. And as much as I maybe appreciated the unfairness that he was feeling in that answer that he received in that situation, the question that I wrestled with there, and that my opinion reflects this, is that these are the words that the legislature wrote, and I don't necessarily know the reason for why they wanted this particular thing to be recorded before the end of the calendar year, but that is the requirement that they put in place. And so I honored that, and I upheld that. And I can't say that that's the outcome that I would have wanted if I was king of the world. But it felt like the outcome, and it seemed like the outcome that was the best reading of the text that I had in front of me. So that's one case. So that case was based on statute. The second case, and this is the one that I think will help draw out the contrast.
Forewarn you that the clock is ticking on.
All right, I'm working. The second case was a valuation case, and the question there was a commercial. I think it was an industrial valuation case, and there the taxpayer was challenging their assessed value. Unsurprisingly, they were challenging that it was too high. No one ever comes and asks for a higher assessed value. And obviously the county disagreed with that, and so they both had sort of warring experts, appraisers who were valuing the property. And what the administrative board below did in looking at the case, they looked at the expert opinions that both taxpayer and appraiser had put forward, or taxpayer and county had put forward, and they concluded that neither value, the specific value that either one had recommended, was supported by the evidence. But what the board did conclude was that the value presented by the taxpayer established a cap. That what it did was it established that, notwithstanding the fact that we don't know exactly what the value of this property is based on the evidence in front of us, we don't know what we call the true tax value, or the market value in use is of the property. We can say with confidence and with certainty that it's less than, and appreciably less than, the assessed value of the property that the county placed on it. And so the question that came before me then was, well, wait a minute, from the county, was, well, can you do that? And so the board imposed the taxpayer's value as the value, even recognizing that it wasn't the actual value of the property, but that the value was, that established some sort of ceiling on the value of the property. And that case was very different, because the question in that case, the only statutory guidance I had was really regulatory guidance, and the regulation said that the burden of proof, that the taxpayer's burden was to prove that the value was, that the assessment was incorrect. Now, I think in a lot of these cases, and usually your best strategy is going to be not to try to prove that it's just too high, but you're trying to prove what the actual value is. But it doesn't say that you had. The statute and the regs did not require proof of the actual value. You had to establish that it was too high. And so in that case, because of the discretion, because I found that the statute provided discretion to the court to answer the question of the burden of proof and exactly what you had to prove in that case, I found in favor of the taxpayer there on the theory that they had met their burden, and ultimately that was a fairer outcome, that we know that it's less, and we should honor that. That's a better system than putting them in a different position. And so the contrast there is between the two sides of on the one hand, I have the legislature telling me and dictating the rules to me. On the other hand, it's committed to my discretion. And I think that very much dictates different outcomes in a case depending on where you're at.
Thank you. Mama?
I'm going to talk about a I keep forgetting, sorry. A non-apportionment case. It's sort of like combined, but because they're husband and wife.
Still need to be. Push
I'm
it
still
up.
muted? It says on.
You are now.
Okay.
Thank you. Yes. Husband and wife, they've filed joint returns, so you know what happens. You know, something happens, you're on the hook for 100% of the tax liability. It was interesting how the factual scenario came about, and the statute in our case was just like what Justin said, ties your hand. So in New Jersey, there's what is called gross income tax, which is your personal income tax. It has to fit in within certain categories, and if it doesn't fit, you can't tax it. So this one, what happened was they filed income tax returns. The husband was a disabled, 100% disabled war veteran. So he was collecting disability benefits from the Veterans Administration, not taxable in New Jersey. He then, his wife is taking him to doctor's appointments, wife is taking care of everything, she got a job, she's doing everything. He comes in and says, I'm done with you, I got LASIK, I met a woman, goodbye, I want a quick divorce. She apparently was still reeling, he walked out, they got the divorce. So she started sort of stalking him, and he was having all these like fabulous pictures with my new young wife, look at my war medals. She looked at it and she said, wait a second, those are for wars before you were even born. So this is how mad she was, I had no fury kind of thing. She called a third-party investigative agency and reported and said, look at this guy. I don't think he even served in any war. It was true. So they then went to the federal government. The federal government did its own investigation based on this report, indicted the guy. He got punished. He was in jail. And then he was supposed to also give restitution for all of the disability benefits that he fraudulently collected. And in New Jersey, you can tax income that was based on fraudulent activity. And this poor woman was given a whopping bill of $15,000 and said, you filed joint return with this guy, you gotta pay the money. And she said, but I'm innocent. And they're like, I'm sorry. New Jersey doesn't have innocent spouse doctrine, only the feds have it. But the feds gave it to me. Well, we're New Jersey. So she comes, and, you know, the argument which I would have made if I were an attorney to a judge, you know, here's a clear statutory requirement, and we don't have the innocent spouse concept in New Jersey. I'm sorry, but you've got to pay. So fundamental fairness was, I said, why are you coming to me so late? Because New Jersey has statute of limitations to audit a return within, I think it's 4 years after it's filed. It's way past the 4 years. Well, you know, Judge, he got indicted and he went in jail, it happened 10 years later, and when there is fraud, there is no statute of limitations, which is true. So I said, but who committed the fraud? And then I went into the fraud statute and I said, you now, taxation, have the burden of proving that there was fraud. So I basically denied summary judgment motion, hoping that they would settle. They settled. I think they took a little bit of money from her, which I think was so wrong. But that's how I thought I did a little bit of fairness, because the statute was clearly against her. She had no relief policy-wise. I think even the federal government, there's more of a, it's not regulatory, it's really like an application for relief under the innocent spouse. We didn't have anything like that. But I think fundamental fairness was, here was this woman, and you have a statute of limitations. You didn't comply with your burden with the statute of limitations, so I'm not going to rule in favor of you. So I think, you know, sort of, I know it's not single source of portion, single source of, I know it's not that, but there was a little bit of combined joint filing.
Yes, thank you.
And fairness.
Anthony, you think you can top that one?
I will just say one thing. As a current serving state military officer, there's something also very wrong with that case. It's called stolen valor, which is problematic in its own right. You know, Joe, you've mentioned due process, which of course the sum total is making sure that those who are aggrieved, have a controversy, and come before any of our constitutional courts or administrative tribunals have had an opportunity to be heard, for the case to be adjudicated fairly, and for a decision to be rendered correctly. One of the things, if I just might take a moment here, Joe, to just say this, that's important to me personally, because we do have a good number of pro se litigants that come before us. This is mainly on the property tax side. It also occurs on the income tax substantiation side, is to make sure as a matter of due process that regardless of the facts that are coming before you, that you're always treating the taxpayer with respect. Because we're at a Catholic law school, I will take some license and just mention some of you, like me, when you were growing up, may have put the initials AMDG at the top of your test paper, ad maiorem de gloriam. I always included, secularized it, and included TTWR, treat taxpayer with respect. And it's very important as judges that you all just remember that, because ultimately we're doing two things up there. We're judging, but we're also making sure that particularly the taxpayer, when they leave the courtroom, they believe they were treated fairly with due process, but also that they have an enduring faith in the rule of law in the democratic system. It's a sacred trust that we hold. And for those of you that have an opportunity to counsel and speak with pro se litigants, it's just important. I think it can't be said too often. With concern to my case, however, and my clerk may be watching, so because he took the trouble of drafting a few top-line talking points, I want him to see that I'm holding them up. I'm on this case, so I'm obviously familiar with it enough. I believe in just a very practical approach to opportunities like this to maybe perhaps share a practice pointer, not only in the Maryland tax court, but most other tribunals or constitutional courts you find yourself in front of. So today, I just want to touch upon the doctrine of estoppel. All right? So my case is Clear Channel Outdoor, LLC, versus the Department of the Director of the Department of Finance of Baltimore City. So I mentioned that we do municipal cases. This is a big one. All right? So this case, I guess you could say it was bifurcated. Earlier on, Clear Channel, it was a billboard case. In 2013, Baltimore City established an excise tax. Remember that now, an excise tax on billboards located in the city of Baltimore. And the tax was levied on all digital and static billboards. Very different, you gotta like, okay? And the tax was obviously, maybe not so obviously, higher for digital billboards. The tax was also...
Before you go on, Pat, do you have a question?
Oh, at the appropriate time. I didn't mean to interrupt.
Oh, okay.
Sorry.
Go ahead, I'm sorry.
Okay, so the taxpayer had paid money, paid it forward to the city. It's asking for a refund. The city says, no, in previous litigation, this is important, in previous litigation, our Supreme Court of Maryland declared the tax did not violate the First Amendment. And both parties, in the run-up to that aspect of the litigation, assumed and litigated with the working definition that the tax was an excise tax. Years later, the case comes before me. In the current litigation, the taxpayer attempts to recharacterize the tax as a non-uniform property tax, not an excise tax. Now, they were stopped from doing this because within that, as a matter of fact, you have to concede whether or not you are an advertising host, which, for reasons that are quite unimportant to this brief presentation, they conceded to when arguing they were an excise tax, litigating the First Amendment, but they changed their mind, okay, with the new tax. They can't do that. And as a practice point, I find, at least in my court, the doctrine of estoppel is significantly underrated. If you have a bifurcated case, if you have a similar same fact pattern where you're having to go back more than once, consider estoppel. So in Maryland, at least, I think we're a little more on the stricter side, our appellate courts, with what constitutes the ability to stop a fact from being pled, okay, by the petitioner's counsel. There are three criteria that must be met. So estoppel is applied when one of the parties takes a position that is inconsistent with the position it took in previous litigation. Okay, right? We're there with that so far. Number two, the previous inconsistent position was accepted by a court. The Maryland Supreme Court obviously accepted and ruled. Third, and this is where the bar gets a bit higher, The party who is maintaining the inconsistent positions must have intentionally misled the court in order to gain an unfair advantage. I'm citing Hall versus National Collegiate Athletic Association, 26 Maryland App 310, 2024. So in this particular case, it was found that all three of those criteria, including the fourth, in fact, triggered estoppel. It was utilized, and Clear Channel failed to prevail that day in the case due to that very particular reason. So as a practical pointer, I would humbly just submit to you that estoppel, and I see it sometimes in cases where it could be utilized, but at least in my tribunal, it is a somewhat underutilized, tremendously effective strategic play.
Thank you. I think that's a terrific pointer. Should be remembered. Okay, Pat, it's yours.
Thank you. I will note that we have three very distinguished jurists from states who have decided to have an independent tax tribunal and specifically a tax court. But not all jurisdictions have an independent tax tribunal. And I was curious, to the extent that you're comfortable doing so, I would love to hear your comments or recommendations to other states who may be considering an independent tax tribunal or a tax court.
Anyone want to jump in on that?
Well, I think you know, it goes back a little bit to the last panel, and as I understand the story of Indiana's tax court, you know, there were a number of different challenges that were encountered in the world of tax prior to the creation of the Indiana tax court. You know, you had forum shopping questions. You didn't have uniformity because you had different trial courts and you had different appellate courts reaching different conclusions. And at least in our appellate system, panel opinions are not binding on other panels, and so that can be very challenging. So you had inconsistency in that way. You lacked a certain amount of expertise and familiarity with tax. You know, it's no surprise that your typical civil courts are not particularly interested or well versed in the world of tax, and find themselves trying to get out of those cases in any way that they can. You know, I often hear comments from my colleagues on the Court of Appeals that they're very thankful that I exist so that I can do the tax cases because they sure as heck don't want to do them. I take that as a little bit of job security. But back to the last panel, I think some of it comes down to articulating the problem, right? What are the benefits that you hope to achieve by creating a tax court? And think about that message. Simple. How do you convey that message in a way that's simple and convincing? And I think it also comes down to those relationships. It comes down to building those partnerships with the businesses and the business community who really stand to be the chief beneficiaries of that. And there's probably a part of that that's aligning as well with those who are interested in the economic development aspects of making your state a more attractive place to do business. I know in our state chamber is very supportive of the Indiana Tax Court. Our business community is very supportive of that. They like having the uniformity that comes from our court. They also like the speed that comes from our court. So cases from our court, they come from the administrative branch. So they come from the Department of Revenue. They come to my court, and the only other place to go from there is the state Supreme Court. So more often than not, my court, I will be the last word on any particular issue, which brings a lot of consistency, certainty, predictability to that system.
Before we run out of time, let me ask if there are any more brief questions. Yes, Chuck.
What is the term of each judge's appointment?
You can just repeat that.
Yeah. What's the term of each judge's appointment, Mark?
I can start. You start at 7 years. It's like you're on probation. In New Jersey, you get nominated and appointed by the governor, and there's no election or anything like that. You're basically nominated and appointed by the governor with the advice of the Senate Judiciary Committee. After the first 7 years, you go through the whole reappointment process. This time the focus is a little bit different. What kind of cases did you do? How often were you reversed? Are there complaints from the public? Did you treat pro se fairly? You know, that kind of stuff. And then it's for until you're 70 or you die, whichever comes earlier.
So Indiana is a lifetime appointment until the age of 75, and then you have to retire. Indiana follows, from an appointment standpoint, follows the Missouri plan for appointments, which means that we have a judicial nominating commission. This is just for our appellate judges. Our trial judges are elected predominantly. It's a commission made up of 3 members of the bar who are elected by the bar, 3 members appointed by the governor who cannot be attorneys, and the chief justice. And so you apply to that group. They make a recommendation to the governor of 3 candidates, and the governor chooses from those 3 candidates. The only accountability function built into that, aside from just judicial qualifications or ethics, is we have to stand for retention elections. So you stand for retention first 2 years after you're appointed, and then every 10 years after that.
Anthony?
It's 6 years and is serving until otherwise replaced or reappointed. I would like to answer that gentleman's question back there. What is your name, sir?
Pat Reynolds, I'm with the Council on State Taxation.
Pat Reynolds. I have an idealistic answer for you and a pragmatic one. Which one would you like?
You're both.
Fine. The reason why
they're short.
Yeah, the reason why an independent tax tribunal is important, idealistically, is because in some important respects, we are guardians of the 10th Amendment, right? That which is reserved to the states. This is the province of the state and the municipality, and we ought to know with great detail how to interpret the laws pertaining to taxation in the state of Maryland. Very important. As a practical matter, when cases are appealed to the circuit court, most of these judges come out of what I would term as a more traditional path to being a trial judge. Family law, criminal law in particular. That's not to diminish them, but it's to say that you can't know everything. So I think that there is a very strong pragmatic reason why you have 5 judges that are experts in the field of state and local tax.
Let me thank all 3 of you. Everyone in this room should know these judges are among the outstanding state court judges, and you're really fortunate to have them here today. It's an incredible presentation. I want to thank you. And to close this out, I want to say that Mike Sims was a friend of mine, and he was an incredible human being, and we all should aspire to that standard. Thank you.
I absolutely could not have said that better.
We're going to try again in about 10 minutes in a tribute to Mike. But first, I want to make sure that we thank a lot of the folks that put this on for us. So the graduate tax program in the law school, Dean Alexander, Steve Olson, Mia, Catherine, Dan, people that you've probably been dealing with technical issues or registration or just the fact that this program existed. So we owe them a debt of gratitude.